2.
Good morning everybody, Miss Walsh here today, and I'm just going to have a little chat with you in relation to Introduction to People and Businesses, Chapter 1, Unit 1 on your course. So I'm going to just talk you through today's lesson. Okay, so the learning outcome for today's lesson is list and explain the main stakeholders involved in business, describe the different relationships that might exist between different stakeholders that are affected by a business, analyse the relationship between the stakeholders in a business, outline the elements of a contract of law, explain how a legal contract can be terminated, and show how breaches of a contract can be resolved in court. Okay, so the first thing we're going to look at, what are the main stakeholders involved in business? And as you all know from class, there's 9 different stakeholders. So let's just look at them individually. So I'll list them first: entrepreneurs, investors, employers, employees, managers, producers, suppliers, service providers, consumers, the government, and interest groups. Now I'm going to talk you through each one and give you an example of each one. So the first one we look at is entrepreneur. And basically an entrepreneur spots a gap in the market for a good or service, then takes on the risk, both financially and personal, of starting a business in order to make a profit. And a very good example there would be Suzanne Jackson. She's an award-winning fashion, beauty and lifestyle blogger who also created her own best-selling beauty brand Sasumi by SJ. The second one we look at is investors. It gives the entrepreneur money, and this money, as we know, is called capital, so that you can invest in the business to help it succeed. The investor will look for a return on their investment in the form of a dividend. And a typical example of an investor would be bank and other investors may give loans to entrepreneurs which they expect to be repaid with interest, but they do not want any ownership of the business. The next one then is an employer, and that's somebody who hires employees to work for them and they're paid a wage or salary. An entrepreneur may become an employer as their business grows. So for example, if a barber sets up a new barber shop, they get very busy as time goes on, they would then need to employ somebody else. And at that point, the employer now becomes, the entrepreneur then becomes an employer. The next stakeholder is an employee, who works for an employer in return for a wage or salary. They are protected by the employment law and usually signs a contract of employment. The next one is a producer, usually manufactures products to sell to customers. They use raw materials which they purchase from suppliers, and as a result they're able to create a finished product which they then sell to their consumers. A typical example would be Cadbury's buys milk from farmers to use in their dairy milk bars of chocolate. The next one is a manager. An entrepreneur may decide to hire somebody to run the business for them. A manager arranges the business resources, making decisions to achieve the entrepreneur's goals for the business and help it succeed. A manager may manage a part of a business. For example, sales manager could be put in charge of the sales department of the business. An accountant might be put in charge of the finance part. The next one is a supplier. These sell finished goods or partly finished goods to a business. They may supply raw materials or partly finished goods to a business to be used to create other products, or else sell the finished stock for resale by the business. Typical example there will be Insomnia Coffee Company. They receive coffee beans from one supplier to make their coffee, but they would also buy in innocent smoothies for resale from another company. Typical example of suppliers. Service providers then offer important services that business need for the running of their actual business. Most businesses need services such as electricity, broadband, banking, insurance, etc. in order for their business to operate. The next stakeholder then is a consumer, and that's a person like you and me who buy goods and services for their own personal use. And then the ninth stakeholder then is the government, And basically the government sets out laws and rules for businesses that operate in Ireland and also pay tax. It offers support to Irish businesses through state agencies like LEO, which is Local Enterprise Office, Enterprise Ireland and IDA, Irish Development Authority. And finally we have interest groups. These represent groups of people who have a common objective and viewpoint. They lobby decision makers. Lobbying is a deliberate effort by an interest group to influence the decision-making process to promote the interests of their members. So a typical example there is ICTU, the Irish Congress of Trade Union, and this is an interest group that represents all trade unions in Ireland. It negotiates national pay agreement with the government and advises and trains other trade union members. Okay, so now a typical way of that this comes up in your exam would be cooperative and competitive relationships. So we look at cooperative and competitive relationships between the stakeholders. Now I'm just going to give you a few examples today. So first of all, I want to explain what a relationship is. A relationship exists between the same stakeholders, for example, two suppliers, or it can also exist between two different stakeholders, for example, an employer and an employee. Now, so we look at cooperative relationships first. So a cooperative relationship will exist when stakeholders work together to achieve a common goal. This is known as a win-win situation. If both stakeholders act in a mutually beneficial manner, they then both gain and are better off afterwards than they were beforehand. Okay, in a typical example, I'm going to look at two different examples with you. The first one is going to be producing suppliers or purchasing managers and supplier. A purchasing manager may ask for credit period to be extended when they're experiencing cash flow problems. If the supplier issues an increase in credit period, they will win as they're buying. If the supplier increases the credit period, they will win as they're building customer loyalty for future sales. The purchasing manager also wins as they will have some time to raise enough cash to pay off their debts and will not face penalties or bankruptcy. Another example of a cooperative relationship would exist between a government and an entrepreneur. The government can invest in export business through state body Enterprise Ireland, which awards grants to business to help them export. This will help the government by increasing the amount of exports sold from Ireland, thereby increasing the revenue for the government. This will help the business by providing them with capital, which will help increase sales, therefore increase profits for the actual entrepreneur. Okay, so that's our cooperative relationship. Now we also have competitive relationship. So what is a competitive relationship? A competitive relationship exists when one stakeholder benefits at the other party's expense. This is known as a win-lose situation. If both stakeholders want different outcomes, when one gains, the other stakeholder will lose. If two parties both want the same outcome, but only one can win, one party will benefit at the expense of the other party. And a typical example there would be investors and entrepreneurs. So an investor will naturally want a high return on their investment. If they negotiate for a higher return from the entrepreneur, they will receive a higher share of the profits and a higher dividend at the expense of the entrepreneur, who will have to give away more of their business, which will in turn have less money to have day-to-day running of the business in the following year. Another example of a win-lose situation or a competitive relationship is an employer and an employee from time to time. An employee will want a fair wage. If employees want higher wages because the cost of living has increased, if they negotiate a higher wage, they will increase their income and the employer will face higher wage costs, which in turn will reduce their profitability. Okay, so what are the benefits then to stakeholders of competitive relationships? The first one there is, I'll just give you bullet points first and then I'll discuss each one individually. There will be a decrease in prices, increase in the range of products available, offer better customer service and improve the quality of its products. So I look at each one individually now. So the decrease in prices. Chocolate producer Cadbury's may lower its prices, either on individual bars or by offering unit packets at a lower price than their single bar, in order to get consumers to buy Cadbury's instead of Nestle or Mars. Now, if the Cadbury's lower its price, it will help them to attract more of Nestle's loyal customers. In this case, Cadbury's will win and Nestle will lose out. Now let's look at an increase in the range of products available. Cadbury's can offer customers more choice. For example, different flavours or different size bars to choose from. In 2019, the company launched bars in 3 new flavours: Cocoa Latte, Simply the Zest and Raspberry Shortcake. If the new flavours attract some of the competitors' customers, Cadbury's will win and the competitors again will lose. Looking at offer better customer service, producers may offer added extras during the purchase and aftercare service or aftercare experience. Nike may offer customers free returns after 30 days. If increased customer service attracts more customers to Nike and away from competitors such as Adidas and Under Armour, Nike will win and its competitors will lose. So we have a win-lose scenario there. And looking at improve the quality of its products, a producer can compete by using better raw materials, improving the performance of its product or increasing the product's durability. For example, a Louis Vuitton coated canvas bag is much more durable than the average leather or fabric bag. By improving this durability, improves customer loyalty. As a result, Louis Vuitton's competitors will lose out as they will find it harder to attract customers. Okay, so now I'm going to talk you through the contract law. And I'm going to give you a definition for contract law. Then we're going to talk through the different elements of contract law. We're going to look at how to terminate a contract and also the remedies to a contract. Okay, so what is contract law then? A contract is a legal binding agreement between 2 or more people. The contract can be written or employed. There's 8 elements to the elements of a law of contract. We've offer, acceptance, consideration, legality of form, consent to contract, capacity to contract, legality of purpose and intention of contract. I'm going to discuss each one in depth and I'm going to give you a little example. Okay, so what is offer? Offer is made when one person asks another person to enter into a deal with her and promises to be bound by the contract if the offer is accepted. She does so by setting out all the terms of the deal clearly, completely and without any conditions attached. An offer can be oral, in writing or by conduct. For example, if you present a bar of chocolate at a till in Tesco, by your conduct you are offering to pay the displayed price for the bar. Acceptance is the second element. Acceptance means that the other person agrees to all the terms of the deal without any condition. So for example, the supermarket accepts your offer to buy groceries once the shop assistant scans them. The third element is consideration. Consideration is something of value which must pass between both parties to a contract for it to be legally valid. Usually money is exchanged for goods or services, but anything of value agreed in exchange for another item is consideration. For example, a customer offers €1 for a bar of chocolate. The money and the item are both consideration. Okay, the fourth element, legality to form. Some contracts must be drawn up in a certain manner to be legally binding. A typical example, if one looks to take out a bank loan for the purchase of a house, the contract or the agreement must be in written form and must be signed by both parties. The next one is consent to contract. Both parties must choose to enter a contract voluntarily. If either party was threatened or forced to enter a contract through intimidation, then it would not be valid if they could prove, then it would not be valid if they can prove that they were intimidated. For example, if a person was given a death threat and forced to sign over shares in a business to another party, the contract would be resigned in court if coercion was proved to have taken place. The next element then is capacity to contract. This is the legal ability and right to enter into a legal contract. A person generally would not have the capacity to enter into a contract if they were bankrupt, under the age of 18, insane, under the influence of drugs and/or alcohol, or a diplomat. The next element is legality of purpose. This means that legally binding contracts can only be for legal transactions. No agreement which involves breaking the law is a contract. For example, a judge will not award compensation to a bank robber whose getaway driver does not turn up as promised. The next element is the intention to contract. The intention to contract means that both parties to the agreement must mean it to be legally binding contract. In Irish law, social agreements are not contracts because there is no intention in them. For example, if Paul promises to wash his mother's car and doesn't, she cannot sue him because it's technically a social agreement. Okay, so that's the elements of contract. Now we're going to look at termination of a contract. Terminating a contract means ending or getting rid of the contract. This can be done in one of four ways: by performance, agreement, frustration, or breach of contract. And again, I'm going to give you an example of each. Performance, when both parties to the contract carry out their duties as required by law. For example, a band is booked to perform at the wedding and the agreement is carried out once the performance takes place. The next element is agreement. The parties to the contract agree to end the contract by mutual agreement or mutual consent. For example, a contract of employment may be ended by agreement if it includes a clause stating that it can be terminated if 1 month's notice is given to the employer. And finally, frustration. If a non-foreseen event happens, this may prevent a contract from being completed. For example, goods for which there is a contract for sale are destroyed by fire. In that case, the contract will be terminated. And breach, if one of the parties does not perform his or her side of the bargain, the contract again can be terminated or will be terminated. For example, a builder is employed to build a conservatory but builds a room with only one window. The second party can take the builder to court. Remedies for breach of contract then. So in other words, if there has been an issue with a contract, how can this be resolved for both parties? The first one is damages. Second one is specific performance and reside the contract. So now I'll discuss individually each one. So damages. The judge can order the person who broke the contract to pay financial compensation to the innocent party, to compensate him for what has lost and suffered as a result of the other person's breach. Specific performance. The judge orders the person who broke the contract to carry it out exactly as she promised she would under the terms of the original contract. Reside the contract then. The judge orders that the contract be set aside and that the two people be returned to exactly the position they were in before the contract was agreed by them. Okay, so that's Unit 1 covered with definitions, and each definition was expanded and relevant examples given, which is necessary for your actual exam going forward. Now, I'm just going to recap by going through the key words. So again, entrepreneur, investors, employer, employee, manager, producer, supplier, service provider, consumer, government, interest groups. All of those 9 key words represent the 9 stakeholders in a business. The next thing we looked at was competitive and cooperative relationships. I gave you clear definition for each one and also 2 examples for each relationship. The next thing we looked at was the ways in which a contract can be terminated: by frustration, by performance, by agreement and by breach. The next area we looked at was the ways in which the remedies that can be given in the event of a contract being breached: specific performance, financial compensation and reside the contract. And finally, the key words then relate to the elements of a law of contract. So there's 8 elements. So you have offer, acceptance, consideration, legality or form, consent to contract, capacity to contract, legality of purpose and intention to contract. Now, there's just a list of questions where this chapter came up in previous Legal Cert higher level business questions. So if you can see, I just gave you references. So for example, 2015, question 1, part A. Question 2017, question 1, part A, and so on and so forth. Okay, thank you very much for taking the time to listen to my presentation, and I wish you the very best of luck with your revision. Good morning, Miss Walsh here. I'm just going to talk you through this morning about consumer conflict, chapter 2, and it's unit 1. Okay, so let's have a look and see what we're going to do. So our learning intentions for this morning's lesson is we're going to look at the outline non-legislative ways of solving conflict. We're going to describe how the CCPC protects the interests of consumers. We're going to outline a consumer's legal rights under the terms of the Sale and Supply of Services Act 1990. We're going to illustrate the provisions of the Act for both goods and services. We're going to illustrate the forms of redress available to consumers for a breach of the Act. We're going to explain the main provisions of the Consumer Protection Act 2007. Evaluate the role of the Small Claims Court or procedure. And also we're going to evaluate the role of the Office of Ombudsman for Public Services. Okay, so first of all I'm going to start off by looking at non-legislative ways of solving conflict. What does this mean? This means that consumers and the shop try to resolve conflict themselves or with the help of others, but without reference to the laws of Ireland or to any other legal agency. And the way in which they're going to do this is through negotiation or by the Consumer Association, or CAI. Okay, so negotiation, so what is that? It's the process of bargaining to try to reach a mutually acceptable solution to the conflict. The first step is for the consumer to go back to the shop where they bought the item and set out his position clearly. He should explain what the problem with his purchase is and set out what he would like the shop to do to resolve the situation. Both will find a solution in order to solve the issue. The Consumer Association of Ireland, or the CAI, is an interest group for consumers. Its aims are to make sure that the consumers get full quality goods and services and good value, and that consumers know their rights. Any consumers who experience difficulty with their goods or services can contact the CAI for expert advice on their rights and on how to solve their problem. Okay, so the CCPC, so what that stands for, the Competition and Consumer Protection Commission Act 2014. This is a relatively new law and does not intervene or become involved in individual disputes between consumers and the seller of the goods or service providers. It is a statutory office and carries out several functions which I'm going to discuss with you now. The first one is informing the consumer of their rights, and that is through social media, website or by their helpline. The second function they have is enforcing the consumer law. The CCPC issues prohibition order, and that is basically a notice to a business to immediately cease an illegal act. They also issue a compliance notice, which is a written notice for a shop to stop certain practice and obey the law by a certain date. They also issue on-the-spot fines for offences relating to price display. They also have name and shame of businesses by publishing non-compliant trader names. They also conduct market research into consumer issues by publishing research on consumer behaviour. Another one of their functions is to educate the consumer. The CCPC website has lots of tools which aim to help consumers make more informed choices. It uses financial calculators to allow consumers to compare the cost of different mortgages by different service providers, credit cards, loans and other products from different providers. They also advise the government on consumer issues. The CCPC advises the Irish government in relation to consumer protection. If it is concerned that consumers need greater protection in certain areas, that could be aided by changes to Irish law. The CPCC will advise the government on this. Okay, so now I'm going to talk you through the Sale of Goods and Supply of Services Act 1980. This act relates to both goods and services. And first of all, I'm going to talk to you about the provision of goods. So all goods sold must be of merchantable quality. And what does that mean? Goods must be of reasonable standard regarding their quality and durability, given the price that was paid for the actual good. For example, a €100 pair of trainers would be expected to be of great durability and quality compared to a pair that you would have paid €10 for. So that's the first provision. The second provision of the Act is goods must conform to a sample. Goods should match any sample used to sell the good from a book of samples in a showroom. So for example, if a consumer chooses a carpet from a book of samples, the carpet should be exactly as the sample carpet. The next provision, goods must be fit for purpose. Goods should do exactly what they're intended to do. So for example, a kettle should boil water safely. Goods must be as described. Goods must match any description used in advertising, shown on the label or given by their salesperson. So for example, a toy should match the picture on the packaging. Okay, so now I'm going to look at the provisions of the Sale of Goods and Supply of Services Act in relation to services. The supplier has the necessary skill to provide the service. So the service provider should have the qualifications and skills necessary to carry out or provide the service. So for example, an accountant should be qualified so that they can properly do the VAT returns for a business. The supplier will provide a service with proper care and diligence. The person providing the service should not rush and should make sure all parts of the service are fully carried out. Typical example, if a car is left at a garage for a full service, but the garage fails to change the oil, this is not acceptable as the service has not been complete. Another element, the materials used must be sound and goods supplied must be of merchantable quality. In other words, the tools or equipment used when providing a service or any goods that a consumer also receives when paying for service should be reasonable or durable given the price spent on the service. So for example, if a photograph is included with a €10 roller coaster ride, the resolution of the photo should be a reasonable quality. Okay, so now I'm just going to talk you through a few different things that comes up as well in this chapter. So what is a guarantee? A guarantee does not remove, limit or replace a consumer's legal right. They are additional protection given to the consumer by the retailer or the manufacturer, and this is often given as an extra selling point to the consumer. They last for a certain period of time and can include a repair, a replacement or a part or full refund. Signs limiting consumer rights then. It is illegal for a shop to display signs or notices in stores that could suggest consumers have fewer rights in certain situations or for certain goods. So a shop cannot have a sign stating no refunds on sale items or a sign stating credit notes only. This is because the consumer has a right to proper redress if a good is faulty, even if it is a sale item. Unsolicited goods. So what exactly is an unsolicited good? A non-solicited good is a good sent to a person who has not ordered them. They have the right to keep them after 6 months if no attempt has been made by the seller to collect them. However, they should be kept unopened in the meantime. Another area I just want to draw your attention to as well is responsibility is with the retailer. When a consumer buys a good from a retailer, they make a contract with the company or the retailer and not the manufacturer. The company agrees to provide certain goods for a certain price. If the purchased goods are faulty, the retailer and not the manufacturer is responsible and must sort out the customer's complaint. Okay, so now I'm going to look at the 3 forms of redress. So as a consumer, if an issue arises, what are you entitled to? There's 3 forms of redress: refund, repair and replacement, also known as the 3 R's. So let's talk you through refund. So refund, if a consumer purchases a faulty good and complains promptly, they're entitled to their money back. If a consumer purchases a new phone that will not turn on, they return it to the shop and get their money back. A replacement, a consumer might receive a new model of the same item or an item of similar quality in place for a faulty product. So for example, a consumer who buys a bike that is not of merchantable quality might be happy to accept the next year's model to replace it rather than a refund. And the 3rd R then is repair. If it suits the consumer, they may ask for the product to be repaired. They might only be entitled to repair or the product or a partial refund. So for example, a consumer's rights lessen the longer the delay making a complaint. If a consumer is not happy with a new tablet but does not complain for more than a year, they might be entitled to have it repaired, but they will not be entitled to a full refund, because a lot of time has lapsed in that situation. Okay, so that's the Sale of Goods and Supply of Services Act 1980. That's an important act. Another important act in relation to consumer legislation is the Consumer Protection Act 2007, which I'm going to talk you through now. So this act is in place to protect consumers' ability to make informed decisions that could be affected by unfair, misleading and aggressive trading practices. Practices are banned if they meet 2 conditions. The first one, they are false, misleading or aggressive, and secondly, they're likely to distort the consumer's choice. Okay, so I'm going to talk you through each one then. So false claims about a product. A business cannot sell fake or counterfeit products claiming that they are the real thing. A business also cannot mislead consumers about the origin of the product. A business cannot mislead consumers about an award or prize that the product may have received in the past, and a business cannot mislead consumers about a good's previous usage. Okay, another element of the Act, misleading advertising about a product. A business must be clear about what is included in the purchase and what a consumer can reasonably accept when buying the good. It cannot mislead a consumer when comparing its goods with those of other companies through advertising or marketing. A little example there would be Aldi cannot claim in an advert that it is selling cheaper sausages than Tesco if it is comparing the price of basic Aldi sausages as opposed to organic Tesco Finest sausages. You're not comparing a like-for-like product in this situation. So again, that would be seen as misleading advertising. Another element of the Act, advertising of false prices. A business must be truthful about the actual price, the previous price and the recommended retail price when comparing the current selling price for consumers. For a good to be advertised in a sale, the comparison price must have been displayed for 28 consecutive days in the same store in the previous 3 months. A shop cannot claim a pair of Nike runners are currently marked at €100 and have been discounted by 50% if they were never actually sold for €200 in the store in the first place. Okay? Another element then is aggressive selling practices. This Act prohibits traders from engaging in aggressive practices such as harassment or exercising undue influence. An example there is a seller cannot pressure or intimidate vulnerable consumers and enforce them to buy something that they do not need or want. Okay? Another provision of the Act is misleading pricing displays. A business must display prices for all its items that are for sale. This allows consumers to make comparisons between different goods, and so they do not feel pressured to buying the goods when they reach the till and are quoted a high price. An example of this, hairdressers must make all their prices available from the street or immediately inside the door of their premises. Okay? Now I'm going to talk you through the Small Claims Court, and I'm going to evaluate the Small Claims Court for you. So the Small Claims Court is administrated by the District Court. It deals with complaints of up to €2,000 or less. There is an initial fee of €25 to apply. No solicitor is needed. Consumer must fill in a complaint form which is completed online, and the retailer has the opportunity to respond to this claim. If the retailer accepts liability or fails to contest the claim, the court will automatically find in favour of the consumer. If necessary, the registrar of the court may interview and negotiate with both parties to try and reach an agreement. The registrar's decision is not legally binding on either party. And just to evaluate then the Small Claims Court, the small claims procedure is a relatively cheap, fast and easy way for consumers to resolve certain types of disputes, generally without having the cost of a solicitor. Okay, so now the final part of this presentation today is what is the Ombudsman for Public Services? And again, I'm going to evaluate the Ombudsman. The Ombudsman for Public Services investigates consumer complaints about activities of public bodies, such as government departments, city and county councils, the HSE and An Post. The Ombudsman will investigate complaints only if the person has tried to resolve themselves first. The Ombudsman is actually seen as a last resort. And to evaluate, an impartial Ombudsman allows the consumer to take on a public body knowing that they will be dealt with fairly. The process is accessible to all as it is free of charge, so a claimant does not have to bring a public body to court. I've compiled previous questions asked in the higher level Leaving Cert on this chapter, and for example the references are 2014 higher level exam paper question 1 part C, 2011 paper question 4 part B, 2017 question 1 part C, and 2013 the short questions, and that one is actually question 2, 2012 question 1 part C, 2016 question 1 part C, 2010 question 1 part B. Now it would be a good idea if you actually practiced doing those questions. Okay, I'd just like to wish you the very best of luck with your revision. Take care. Good morning everybody, Miss Walsh here this morning. I'm going to do a lesson with you on international environment, and this is coming from Unit 7. Okay, so let's look at what we're going to cover into this morning's lesson from international trade. Okay, the areas are: outline what an open economy is, explain what trading blocks are and the benefits of being part of a trading bloc, distinguish between different types of imports and exports, and why trade internationally and who trades internationally. We're also going to look at measuring international trade, the barriers to international trade, and finally we're going to discuss the challenges and opportunities of changing nature on a global company or global economy. Okay, so we'll begin by talking about what is international trade, and the definition for international trade involves selling goods or services to consumers outside of a domestic economy. Okay, so what is an open economy then? Ireland will be classified as a small open economy, as it engages in international trade through importing and exporting of goods and services. And it's important to note that nearly 80% of Irish goods are exported. So, a trading bloc. So a trading bloc is a group of participating countries which allow free trade between them. There is no tariffs or trade barriers in place between these countries. Types of trading blocs. So there's three main types which I will talk you through. First one being free trade area, the second custom area, and the third common market. So when we talk about a free trade area, it is a group of countries that agrees that the member countries can trade freely with either reduced or no tariffs or barriers imposed on any of them. And a typical example there is the North American Free Trade Agreement, or the NAFTA, and this is an agreement between North America, Canada and Mexico. The second one is the customs area. Member countries agree to freely trade without imposing any tariffs and impose common tariffs on countries that are outside the Union. And a typical example here is the European Union. The third one is the common market, also known as a single market, and this is where all barriers to trade in goods, services, capital and labour are removed. Typical example, the EU has a common fisheries policy, or the CFP, that applies to all member states. Okay, so I'm going to talk you through imports and exports then. So we'll start off with the definition of imports. So import is the purchase of goods or services from other countries. In the case of all imports, it's important to note that all money flows out of our economy as we pay for the purchase of foreign goods and services. There's two types of imports. We have visible imports and we have invisible imports. So let's look at visible imports first. These are all tangible goods produced from abroad. A typical example would be Spanish oranges, Spanish holidays, tea, coffee. In the case of visible imports, these goods arrive into Ireland. As these goods arrive into Ireland, the money flows out of Ireland and in order to buy the goods. So for example, Spanish oranges come to Ireland, money will leave the Irish economy and head towards the Spanish economy. Invisible imports then, these are basically services purchased abroad. Typical example, when an Irish citizen holiday in Italy, not only do they leave our money, our country, but their money also flows out of the Irish economy as they pay for their foreign hotels, etc. Okay, now just to summarise, it's important to note that visible imports are Irish people who buy oranges from Spain. Invisible imports, a very good example, is Irish people holidaying in Spain. In both cases, the flow of money is from the Irish economy to the Spanish economy. Okay, so now I'm going to look at exporting. And just like importing, we have visible imports, we have visible exports, and we have invisible exports. Exporting is Irish producers sell goods and services to other countries. So visible exports, an example will be a US citizen who buys agricultural produce such as beef from Ireland. Invisible exports, the US citizens holidaying in Ireland. In both cases, the flow of wealth or money is from the US economy to the Irish economy. So why does Ireland trade internationally? Okay, there's a number of reasons for that, and the first one there will be we have limited factors of production. Ireland lacks natural resources such as skilled labour, capital or enterprise to produce certain goods. Land is usually the limiting resource, and in particular our climate is unsuitable to grow certain products such as tropical fruits and vegetables. Another factor, raw materials. Certain essential raw materials are not available locally and need to be imported. Typical example of these would be fossil fuels such as oil, coal, gas. Another reason, customer choice. Irish consumers demand certain goods and services which are not produced domestically. For example, wines, cars, lorries, etc. Another factor would be currency. Ireland needs to export goods and services in order for them to earn the foreign currency which is needed to pay for essential imports. Another factor would be the size of our market. Our domestic market is very small in Ireland. So in order to benefit from the economies of scale, producers need to sell goods abroad. Exporting also helps a business to diversify or expand. Okay, so now we're going to look at who actually trades internationally. So indigenous firms, these are Irish owned businesses who produce goods here in Ireland. The agriculture or the agribusiness sector has many examples of such companies. For example, Glanbia, the Kerry Group, they all engage in international trade. Exports by indigenous firms account for approximately 10% of the total Irish exports. Transnational companies, the vast majority of goods and services produced by TNCs in Ireland are distinctive from export markets. These companies contribute enormously to employment in Ireland and also account for almost 90% of our total exports. Okay, so now an important element of this unit is measuring international trade. The balance of trade, balance of invisible trade and the balance of payment are all measures of a country's level of international trade. The balance of payment is probably the most economically significant one. So let's have a look. Balance of trade basically is the difference between visible imports and visible exports. Okay, so when the visible exports are greater than visible imports in balance of trade, is a surplus. And when the visible exports is less than visible imports, balance of trade is a deficit, and that is a negative impact on the economy. Let's look at the balance of invisible trade then. This is the difference between invisible imports and invisible exports. So when invisible exports are greater than invisible imports, the balance of trade is a surplus, which is a positive for the economy. When invisible exports is less than visible imports, then the balance of trade is a deficit, having a negative impact on the Irish economy. Balance of payment looks at the difference between the total imports and the total exports. This is the best for a country to export more than its imports. So just to summarise that, total exports greater than total imports, and that means that the balance of payment has a surplus. When the total exports is less than your total imports, the balance of payment is a deficit. Okay, and I've just done a question for you. It came up in the Dublin Examining Board mock question 2020 higher level leaving cert. Question 3A. So it gives you the invisible exports, invisible imports, the total export and the total import. You're requested to calculate the balance of trade using the figures provided. You must show your workings, and that's for 14 marks. On the next slide I have the solution to that, and it has a breakdown of the marks as well. Okay, so I'll leave that with you. Okay, so now we move on to the barriers to international trade. What is a barrier to international trade? It's something that prevents international trade from taking place, and there's four main elements: tariffs, embargoes, quotas and subsidies. I'm going to discuss each one now, and the first one I'm going to look at is tariffs. So what is a tariff? It's a tax on import. It raises the price of the import and discourages consumption of it. This can help to persuade consumers to purchase domestically produced goods instead of imported goods. Typical example there, in 2018, Donald Trump imposed a 25% tariff on all steel imported to the US. He did this because he was convinced that cheaper Chinese imports were hurting the US manufacturing. The second one is an embargo, and an embargo is the total ban on importing a product from a certain country. For example, Ireland was allowed to export Irish beef to the USA again after a 15-year embargo. This embargo was lifted in 2015. The ban was initially put in place because of mad cow disease crisis here in Ireland. And the quota then, so what is a quota? Is the limit on the number of units of a certain good that can be imported into a country. For example, in the past, the EU had a quota limiting the amount of clothes and textiles that could be imported into the EU from China in order to protect EU producers of clothes and textiles. And the final one is subsidies. These are grants and payments from national governments to domestic firms to help them with their day-to-day operating costs. Example of this, the EU has subsidised agriculture and aircraft manufacturing in the past. This protects them from their non-rival EU competitors. Okay, now I'm just going to look at the Irish opportunities from international trade. So by Ireland, the Irish economy engaging in international trade, what opportunities does that give to us as an economy? The first one is free trade. The second one is foreign direct investment, FDI, balance of payments, and finally technology or world-class manufacturing. So again, I'm going to look at them individually, and we're going to start off with free trade. Deregulation. So what is deregulation? It's the removal or reducing of barriers to trade. So deregulations of international markets provides Irish firms with increased access to huge overseas markets. This should promote growth, diversification, and therefore increase profitability. The second one is foreign direct investment. Our location within the EU trading bloc, the availability of skilled labour and high level of government investment makes Ireland a very attractive location for transnational companies or TNCs. This is a good form of employment for the Irish people. The next one is a balance of payment. An increase in Irish exports will have a very positive effect on our balance of payment, and therefore will boost the level of economic growth. And the last, technology or world-class manufacturing. Most transnational companies which locate here use cutting-edge technology and are world-class leaders in their industry. Irish workers and management gain valuable exposure to such world-class techniques. This knowledge is frequently used or applied to indigenous industries. Okay, so that was the opportunities. Now I'm going to look at the Irish challenges from international trade, and the four main ones I'm going to look at are increased competition, dominant firms, and language or culture, and also distribution. So starting off with increased competition, deregulated global markets also mean Irish firms face increased competition. Many industrial sectors, especially those where low-cost competition prevails, have found it very difficult to compete and survive, and a typical industry there would be the clothing industry. Huge competition. The next challenge will be dominant firms. Global markets are increasingly dominated by a small number of highly diversified transnational companies. Such companies have a huge advantage over our smaller rivals, and very few indigenous businesses are in a position to compete with these industrial giants. The next challenge will be language or culture. Irish producers who trade internationally will need a good understanding of the marketing and cultural needs of overseas markets. Goods will need to be adapted or modified in order to meet the customers' or legal requirements. Dealing with clients who do not share our language can also prove difficult. Distribution. International trade will inevitably involve additional transportation costs. Due to Ireland's geographical location, as we're situated on the periphery of Ireland, the impact of these costs may be greater. Okay, some of the questions that have come up previously in the higher level Leaving Cert papers are as follows. 2016, question 3, part C. 2010, question 3, part A. 2011, and that's the short section, short questions, question 5. 2017, question 3A. 2013, question 3B. 2011, question 3A. Now, I would advise that you would have a look at those questions and familiarise yourself with them. Okay, just to recap down on what we've done in this lesson, important terms and key words to remember. So we looked at what is an economy, trading blocks, free trade area, customs union, deregulation, visible exports, invisible exports, visible imports, invisible imports, barriers, tariffs, embargoes. We looked at quotas, subsidies, administrative regulations. Okay, I would advise you to go back and recap on all of that. Abbreviations then, and such abbreviations often appear in section A of your exam papers. NAFTA, the Northern American Free Trade Agreement, EU, the European Union. CFP, Common Fisheries Policy. TNCs, transnational companies. BOP, balance of payment. FDI, foreign direct investment. Again, these are quite common abbreviations which need to be noted from this chapter. Okay, I just want to wish you the very best of luck with the revision of this chapter. Thank you for listening and take care.